Welcome back. You're watching All Angles on eNCA. Now, this is fascinating. We've been mulling this whole idea of mandatory vaccines in various settings for a while. It seems now we're starting to generate some level of, legal precedent or some pathways in as far as the law is concerned. What am I talking about? The CCMA has ruled that the dismissal of a woman who refused to be vaccinated against COVID-19 is justified. She had lodged a dispute with the CCMA for unfair dismissal after she was fired for refusing to get the jab. She had been working for a company since 2018. Her employer told the CCMA that it had implemented mandatory vaccination after consultations with employees and unions over 3 months. To get some analysis on these outcomes, let's talk to litigation attorney Mthokozisi Maphumulo about that particular outcome. So a broad question to start off with, Mthokozisi. As I've been saying, this has been a debate that's been raging, but at a conceptual level, this is where now the rubber meets the road, in that you've had a case of someone being dismissed for refusing to be vaccinated in terms of a company's mandatory vaccination policy, and it was couched along the lines of saying that she is permanently incapacitated simply because she did not get the vaccine. Your overall impressions around this decision of the CCMA?
Thanks to Lasizo, and thanks to your viewers as well. To start with, we must remember or take into account the fact that not all cases are going to be the same. Each case is going to present its own peculiar facts, peculiar circumstances, and the reasoning on behalf of the employees as to why they do not want to take, or rather refuse to take vaccination. In this particular case, the reason was that a forced or mandated vaccination intrudes into the employee's right in terms of Section 12 being the bodily integrity, Section 12 of the Constitution. But now, if you are going to rely on Section 12 of the Constitution, we know that every right in the Constitution is subject to limitation in terms of Section 36. That is to start with. And also, there are various laws that really do allow forced, if I can put it in those terms, forced medical, medical service being imposed onto a person. So if the CCMA finds that procedurally the policy came into effect after the necessary legal steps having been, considered, and they are legally justifiable, they are in line with the laws, and substantively the policy, there's nothing wrong legally speaking, then yeah, it's quite difficult to argue for the employee.
So in delivering the decision, the commissioner at the CCMA, please bear with me, I will read back a little bit of a chunk from their decision here. The commissioner says the company at the CCMA hearings relied on a memo that had been sent by Judge Roland Sutherland to his colleagues about this whole issue of vaccinations. And the quotation that is relied upon, which also builds up nicely to the commissioner's decision from Judge Sutherland, says, quote, "There has been as yet only mild protest that this adopting a no vaccination, no entry policy violates freedom of choice. In my view, this is the wrong question. The proper question is whether or not an individual is sufficiently civic-minded to appreciate that a duty of care is owed to colleagues and others with whom contact is made to safeguard them from harm. If one wishes to be an active member of a community, then the incontrovertible legitimate interest of the community must trump the preferences of the individual." Are we on a path? I know that it's a memo from a judge to his colleagues. It's nothing, that's precedent setting. But does it send us on a particular path that we can expect more and more presiding officers to start thinking along these lines when these cases come up?
You quite correctly point out to say it's not legally binding, it's a memo. So the views of the judge, of course, I mean, if it's made in that context by the judge president of the High Court, some commissioners at the CCMA may be inclined to consider those views, but they are not legally binding. They can, if there can be the legal arguments made to kind of dismiss or to convince that those views should not hold water, then those can easily be kind of thrown out. So as to whether we are likely to see this view being adopted by most institutions, it is probably going to be the case, but it's going to also, in my personal view, going to differ from industry to industry, because you, before you kind of trump upon the Section 12 right, there may be industries where there may be certain necessary steps taken by the employer to kind of accommodate people who aren't comfortable with, these forced vaccinations. So in some instances, it may be legally justifiable to kind of force. In some institutions or some industries, it may not be so. If, say, for an example, you do not work in a crowded environment, or some people can work from home, it's not necessary that you interact with the other colleagues. Yeah. Then in those instances, the facts, the circumstances will determine if the forced vaccination is justifiable or not.
In fact, you do point to something that is contained in that decision of the CCMA. The circumstances around this particular employee are also considered. A last aspect that I'd like to tease out with you, Mthokozisi, is the whole issue of exemption, because a lot of these institutions that have mandatory vaccination policies offer an exemption policy that says, actually, if you need to be exempted, you will be and won't be required to be vaccinated under certain circumstances. This person, in this case, we are told, first went the path of trying to get backing from a medical officer to say, I need to be exempted on medical grounds. Did not succeed. Then went the path of, bodily integrity, Section 12 that you talk about, and said, I don't want to have my bodily integrity violated. And this is the decision that has not succeeded as well. Other possible avenues could have included issues such as freedom of religion, etc. But what does this tell us about how hard it will be to be exempted from the norm that says if you work at this company, you must be vaccinated? How difficult will it be if this woman's argument of bodily integrity was simply not sufficient to give her an exemption?
Yes, those two exemptions being an exemption on the basis of medical justified grounds, and the other one being religion, the most prominent at this stage. And it's not going to be easy to get those, because for an example, if you want to rely on the medical grounds, it has to be a certificate or a report by a doctor stating that you cannot, or the vaccine, well, you should not take the vaccine. And that conclusion by the doctor has to be based on the medical fact. Then also, religion-wise, I know in some institutions you've got to get a certificate or a letter from a religious leader, and though that particular leader must be a member of a certain group or a certain association, or the body that they fall under. So they must be regulated at the highest level. So it's not just going to be that easy to rely on the exemptions, and it's probably we are going to see more dismissals based on the refusal of the vaccines, unfortunately.
Sure, yeah, it's a brave new world. We are in uncharted terrain, at least legally, in as far as this issue is concerned. Mthokozisi, I've got to thank you for your time. Mthokozisi Maphumulo there is a litigation attorney, just talking to me about this issue that came before the CCMA that has come to the conclusion that the dismissal of this employee for refusing to be vaccinated and failing to be given an exemption to the mandatory vaccination policy is fully justified.